now we'll start Unit 11, which is based on real estate contracts. 12% of the examination for the state comes from this chapter. So 12 of your questions on your 100 question exam will come from this section. Okay, so let's start with real estate contracts. So what are contracts? So contracts in general, it defines the party's legal relationship and spells out each party's rights and duties. It's a voluntary agreement or promise between legally competent parties. And every contract has an underlying, there's an underlying promise in every contract. So underlying every contract is the promise of something. Does that make sense?
Yeah.
Okay. So the authority of licensees to prepare contracts. So what are licensees allowed to do? Okay. Licensees may assist buyers and sellers with completion of 4 types of contracts as directed. There's the listing agreement, the buyer broker agreement, the sale and purchase contract, and option contracts. There are the 4 types of contracts that real estate agents are authorized to complete with and assist the buyers and sellers with doing that. Now, there's also addendums and amendments and things like that. That's all part of these. It's all underneath these. Okay. Okay, the essential elements of a contract. A valid contract complies with contract law and contains 4 essential elements. Okay, 1, contractual capacity of the parties. That means they're competent parties. They both have to be competent to go into a contract. Number 2 is offer and acceptance. There has to be a mutual assent. They call that the meeting of the minds. There's an offerer and an offeree, and they have to come to that acceptance. Okay. Number 3, there has to be legality of object, a legal purpose to convey property, to buy a property. There has to be a purpose, right, for that contract. And number 4, there has to be consideration. That's a thing of value given in exchange for some other value. And it has to be valuable, measured in the terms of money. It would be a deposit. It would be, something in the value of money. Okay. A good, it cannot be measured. It can be a good or a valuable, but it cannot be measured. Let me re-say that. So a good is something that cannot be measured in terms of money, such as love and affection, right? So you can't put love and affection down as a consideration. Okay. You have to put something valuable down as consideration on the contract. Does that make sense?
Yeah.
Now you have this in contracts, you have the statute of frauds. Okay. Now this requires contracts conveying any interest in real property and contracts that are not performed within 1 year, that they must be in writing and signed to be enforceable. So they have to be performed within 1 year, or they must be in writing to be enforceable. So these types of contracts relate to this are purchase and sales contracts, option contracts, deeds and mortgage instruments, lease agreements for a term longer than a year, listing agreements for a term longer than a year, buyer representation agreements for a term longer than a year. Okay. Now you also have statute of limitations. So if there's a problem with the contract and somebody wants to sue somebody or something was wrong, there's the time period set by statute during which the term of contract may be enforced. A written contract is 5 years. An oral contract, which is also called a parole contract, so parole and oral are the same, you have 4 years. Okay, that's the limitation the law allows. Now, the elements of a valid enforceable contract, the acronym is COLIC. This is going over what we just talked about. You have to have competent parties, offer and acceptance, the meeting of the minds has to be an agreement, a legal purpose for the contract. It must be in writing pertaining to the statute of frauds. and consideration. There's got to be a value or good for consideration. Okay. Now, there's void contracts, voidable contracts, and unenforceable contracts. You need to know this and you need to know the difference. Okay. A void contract does not meet all the required elements of a valid contract and therefore is not legal. Somebody makes an offer, they sign it, everything's good. They don't put no consideration. They never put a payment. Invalid it's a void contract, right? Contract gets signed, somebody's drunk. That's not a void, right? They're not competent parties, right? That's an example of that. Okay, avoidable contract. This allows one of the parties to potentially disavow contractual duties. So let's say you do a contract and they find out the person's 17 years old. They're a minor. They can't do a contract. That contract's voidable because they're not able to do a contract, right? If they put the wrong land description, right? Remember we talked about the property description? If they don't put the proper language in there, that's voidable, right? By one party. Okay, so you have void, voidable, and then unenforceable. Unenforceable is a contract that will not be enforced in a court. It does not comply with the statute of frauds or exceeds the time of statute of limitations. So the time ran out, it violates the statute of frauds. No court will enforce it. It's not enforceable. So unenforceable is a court won't enforce it. Okay, you got the three different ways that you got. Does that make sense? Those three ways?
Yeah.
Okay. So let's look at classifications of contracts. You have formal and informal. Formal is written, and historically it was under seal. Like they would actually seal it, you know?
Mhm.
And informal is oral or a parole contract. So formal is written, informal is oral. Now you have a bilateral and a unilateral contract. A bilateral contract obligates both parties to perform. A unilateral contract only obligates the one party. So a sales agreement is a buyer and a seller. They both have to sign that. It's a bilateral agreement that binds both of them. That's bilateral, like a sales contract. Okay, an option contract is a unilateral contract. An option contract is when a seller says, look, I'll sell you the property for $500,000 within the next 24 months. Okay, I'm going to sign it. I can't back out of it as the seller. There's my offer to you. You can buy it in the next 24 months. I can't sell it to nobody else. I can't do anything. I sign that. The seller signed that. The buyer has the option. The buyer can buy it, or they can say, no, I'm not going to buy it. So that's a unilateral contract. The seller committed and the buyer has the option. Does that make sense?
Yes.
So unilateral is one person commits. Bilateral is both parties commit and perform. Okay.
Okay.
Okay. You have expressed and implied classifications. Okay. Express is an agreement between the parties orally or in writing. And implied means obligations and conditions are not stated, but may be reasonably implied. Right? Make sense?
I didn't quite get that.
Okay. Express is a contract. It's written. Everything's in it. Right? Contract's written, signed. Everybody agrees to it. Implied would be the washer and dryer are connected in the house. It's connected. It's in the house. Nothing in the contract, nothing on the listing says the washer and dryer is not included. It's implied that the washer and dryer is included.
Oh, okay, okay. It's like when there's some sort of features but they're not.
I'm just using that as an example. But yeah,
Oh, okay.
yeah. But I'm saying if it's connected and it's there, it's implied that it comes with the house, unless you say it's not coming with the house, right?
Gotcha.
That's implied because it's there. Now, if you went through the house and there was no washer and dryer, it's implied that there is no washer and dryer, right?
Question for you. Does that also include, or could that also be an implied contract whenever we are working with a client and we have a contract with that client or with that customer, and we're a transaction broker with them, it is implied that we are a transaction broker, therefore.
Yeah, that's true. That
That's
is,
what I'm saying.
yeah, it's implied. It's all, yeah, that's a way to look at it too. Yeah, sure.
Okay,
Sure.
thank you.
Absolutely. Yep, that's a good example. Now you have also executory and executed. Executory is an agreement involving promises to be completed at a future date. Executed means all the parties have completed their obligations. So executed is when a contract is fully executed. You make changes to it, everybody initials it. The last initial is done, it's executed, right? It's done. Executory means you have an agreement, you send it to them, but they haven't signed it yet. It's executory, still needs to be signed. Executed means it's signed. Does that make sense? The difference? You're muted. You're muted, man. Okay.
Sorry, so one is signed, the other one is not signed.
Right. Well, it's to be signed. It's already discussed. It's a promise.
Okay.
Send it over, we'll sign it. So I send it over, it's just not signed yet. That's executory.
Executory. Okay.
Yeah. And if it's signed, it's executed. If it's just not signed, it's not executed. Right? If they don't, sign it, it's just dead. Right?
Got it.
Executory means it's getting signed. Executed means it's already completed.
Got it.
Now let's talk about contract negotiations. Okay. An offer shows intention to contract. That's the buyer's intention to go into a contract. So the parties to an offer is the offerer. That's who makes the offer. And the offeree is receiving the offer. That's the seller. So the offerer, the buyer, is making the offer. The offeree is receiving the offer, the seller. Now there's also a counter offer. So let's say an offer comes in. Okay. The seller looks at it. We look at it. And they say, well, no, we want this much. So we make a change. We put the numbers on there. We send it back. That alters the terms of the original offer. Okay. That nullifies the original offer and substitutes it with the new offer. So that original offer is dead. It doesn't exist anymore. The minute I change it and send it back, you can't accept that offer anymore. That's gone. Okay. Now, let's say we make a counter offer and send it back and they don't accept it. The buyer doesn't accept it. They can counter offer back to me and that would kill that offer. And then that one's a new one, right? Does that make sense?
Yeah.
Now, if I send it back to them and the buyer says, no, we're not going to buy it. No, thank you. And then the seller says, you know what? Let's take that offer. I call them back and say, hey, agent, my seller decided to take the original offer. However, I need you to rewrite it, sign it, and send it over new because that first one's dead. We can't go back to that.
It's voided.
Right. That's a scenario you need to understand, right?
Gotcha.
Okay, good. Now, let's look at ways an offer is terminated. Okay, so if a buyer makes an offer, that offer gets terminated certain ways. And the acronym for this is wild card. Okay, so when a buyer makes an offer, and let's say the offer is going to the seller and the seller is looking at it, but they haven't answered yet, the buyer is able to withdraw the offer. They can say, you know what, cancel that. I don't want to do it. That's called a withdrawal by offeror. That's one way to terminate it. If the person making the offer is insane, is insane or mentally not fit. Lapse of time. When you make an offer, you say, I need to know an answer by 5 p.m. tomorrow. If that time passes, that offer is dead. If they want to accept it, you have to do a new offer. Death. If the person making the offer dies. Counter offer, right? So now if the seller gets it and they counter them, that kills it, right? If the seller accepts it, that kills it because now you have a contract, right? The offer is gone when it's accepted.
Got it.
The seller can also reject it. That kills it. And last is destruction of the property. Hurricane comes through, fire, right? Any of those things will terminate an offer. Okay. Now let's look at termination of contracts. So once you have a contract signed by everybody and you have a contract in place, a contract is terminated when any of the following happens, and the acronym is BLIMP. Performance, that means it closes, right? The deal closes. The transaction happens. That terminates the contract. Mutual rescission. The buyer and seller both agree, let's just cancel this, let's not go forward. That's called renunciation. They renounce it, right? Renunciation. Mutual rescission, renunciation. Impossibility of performance. So if there's some kind of impossibility to perform on the contract. Lapse of time. The contract's supposed to close September 30th. It never closes. It'll void the contract. However, that'll also lose the deposit, sell, there's a lot of things that happen with that. And then breach of contract is when one party doesn't follow through with what they promised. That's the 5 ways that a contract can be terminated. Now, just because it terminates doesn't mean there's no accountability, right? So if you breach a contract, there's remedies. There's lawsuits, there's losing deposits, there's a lot of things. So there's 4 legal remedies imposed by the courts for breach of contract. Number 1, you have specific performance. Okay, this is where a court orders the party who committed the breach to perform as stated in the contract. It's called relief in equity, sought by a buyer seeking the other party to do as promised. That's like when the seller backs out and says, I don't want to sell it. The buyer can go to court and the court can make them go through on the contract. They can force it. That's called specific performance. You got to perform. Liquidated damages. If a buyer defaults, the seller may retain the deposits as liquidated damages. They just take the deposit and move on. Right?
Got it.
Okay, so that's like, for example, a buyer's buying the property. They never close on the property. Okay. So that's liquidated damages.
Question.
Mhm.
Could you give me some examples of breaches? Like, what are the normal breaches in contract?
Yeah, like, okay, so let's look at once. A seller just decides not to sell. I'm not selling my house. Too bad. That's this where they can do this. Liquidated damages. A buyer puts down $20,000. They have a mortgage contingency for 30 days. They got to get their financing in place in 30 days. 32 days in, their mortgage falls apart. They can't get a mortgage. They breach the contract. They lose their money. They have a 7-day inspection period. They inspect the property. Everything's good. 10 days later, they say, oh, I don't want to buy it because it needs a roof. They don't want to do the deal. Breach a contract. They lose their money. Right?
Gotcha.
That's examples, right? Rescission. Okay, this is cancellation of the contract and parties are restored to their original position. So if they don't agree and they fight and argue, but the rescission would be if they actually come to an agreement, say, look, it's fine, it's over. That's rescission, right? The court can actually do that and say, look, you get your money back, you move on, right? And compensatory damages. This would be unliquidated damages. That's like the liquidated damages are just what's involved in the deal. That's like the deposit. However, let's say a seller says, I'm not selling you the house, forget it. And it takes 5 years in court to make them buy it. The buyer could have lost money in that. It could have been time, pain, suffering, expenses. Okay, so compensatory damages will give them money on top of the money they would have gotten. It's in addition. It's unliquidated. It's extra. And there's a civil suit for money damages suffered because of the breach. So that's the 4 remedies for breach of contract. Okay. Got that? Any questions?
No, but those five are all the ways that the court would fix the issue.
Yeah, for breach of contract. That's the 4 remedies. Yep.
Okay.
Okay. Go ahead. We're good. What do you got? Question?
No. Let's do it. Let's do it. We have,
Okay.
yeah.
Now, the next thing, you need to know both of these. You'll see something on these. Assignment and novation. Okay. An assignment occurs when one party transfers rights and duties to another person. You have an assigner and assignee. This is when you have wholesaling property. And I go and I find a property, buy it for $100,000. Okay, I have the contract. Now, if I find somebody to give me $125,000 for it before I close, I am the assigner, they're an assignee. I'm assigning the contract to them. I'm going to make $25,000 when it closes, not touch it, right? That's called an assignment. Okay. Or an assignment can be, I put the contract in my name, but I'm going to open up an LLC before closing. I'm going to put the house in the LLC's name instead of my name. So I'm going to assign the contract from me to the LLC I'm setting up. Does that make sense?
It definitely does.
Okay. That's the way assignments work. Just a couple examples.
Is that that's like an example? Is that whenever they want to use like an FHA loan and then, but they cannot do an FHA loan if it's in their name primarily? I mean, if it's in the LLC's name, so that's why they put it in their name first and then transfer it. Is that what that is?
Say it one more time. With an FHA loan?
Yeah. So in the example that someone assigns, like pretty much gets into a contract with their own name and then assigns it to their LLC later. Could that be because they want to use an FHA loan on the property? That's why they're using their name for it. But then they also want to have it in their LLC. Like, is that why they would do that?
When they're assigning it, yeah. I mean, you would assign it to the LLC, right? An LLC you're putting in for legal reasons, for ownership,
Yeah,
for privacy.
got you. But can you put in a property in your LLC and still get an FHA loan?
Yeah, because you're qualifying for it.
Oh, nice.
I would think so. I mean, well, it depends. See, it depends on the lender because an FHA loan, you may not be able to actually.
Yeah, I think I heard that somewhere that for
I'll
you
tell you
to.
why. I'm just thinking about that now. An FHA loan has to be lived in by the person. If an LLC owns it, it's a business.
Gotcha.
So an FHA loan, you would have to have it in your name most likely.
Mm-hmm.
I can check into it for you. I believe because you have to live in it, it can't be owned by a business. A conventional loan could be. I don't think a VA loan could be. A VA loan has to be in the name of the VA of the person, right? The military person or the spouse.
Military. Got it.
So I don't think so. I'm not 100% on that. I got to find out.
All
But
right.
I don't think so. I highly doubt it.
Okay.
Yeah.
What about trust? Would you say that it's the same case with the trust, or would
A trust, no. A trust, you can't. A trust is, yeah, a trust wouldn't be able to qualify for FHA. I'm sure of that.
got it?
I just don't know. An LLC be the same thing. It probably won't. Probably won't. I'll look into that and I'll get it back to you. I'm just not 100% on the financing side.
No worries. No worries.
Okay. So that's the assignment. You're good on that, right?
Yes. Assignor,
Right.
assignee.
Yep. Now a novation. Novation is an agreement that occurs when a new party is substituted for one of the original parties. It's a discharge. It discharges the original party from the obligation. So if I put a contract in I buy a contract. I get do a contract. I'm buying the house, right? And I decide to put it in Aiden's name. A novation agreement would be me coming off and Aiden going on,
Okay.
taking my place. Okay. That's an example of that.
Got it.
Okay. Now let's talk about listing contracts. It's an agreement between an owner and broker. A listing contract may be written, oral, or implied. However, I require them to be written because you can't, how do you prove an oral or implied, right? Listings for a term longer than 1 year must be in writing to be enforceable. A sales associate's authority is derived from the broker. Remember, the agreements between the broker and the seller The sales associate represents the broker. Their authority is derived from the broker, right?
Yep.
Written listing requirements. Written listing contracts must include the following: a definite expiration date, description of the property, listing price and terms, the broker's compensation, the fee or the commission they're charging, signatures of the owners of record. So whoever's the owners, and remember, if it's one spouse and a homestead, they both got to sign. Remember we talked about that?
Yep, we did.
So signatures of the owners of record, and a copy has to be given back to the seller within 24 hours of signing. If you don't give that copy back, it's a void agreement. You got to give that back. You got to have an email chain showing that went back to document it. And an automatic renewal clause is prohibited. So if there's a definite end date, it can't renew automatically. You would have to do an extension. There's a form, modification form. You would extend it. Okay. Or it would expire and you would do a new one, right?
Well, what does that mean? Like what would expire? The contract?
Right. So say you're doing a listing and you're doing a 6-month listing. You don't sell the house in 6 months. That listing would expire.
Yeah.
Now you either extend it or you would write a new one, right? But it does not, you cannot put in there, it automatically renews another 6 months.
Gotcha.
You can't put that in the agreement. Okay, so let's talk about the types of listing agreements. There's 3 types. Okay, there's an open listing agreement. And to the agent, it's one or more brokers. Only the broker who sells the property gets paid. So if you do an open listing agreement, a bunch of brokers can list it. Whoever brings the buyer gets paid.
Got it.
Okay. An exclusive agency listing agreement. That's one broker. And the commission goes to the listing broker if not sold by the owner. So an exclusive agency is when you're dealing with somebody who wants to try to sell it on their own. You can say, look, if you sell it on your own, you don't pay me. If I bring the buyer or my advertisement brings another agent who brings the buyer, you pay me. Right? That's like if you're dealing with the for sale by owner and they want to try to sell it. Or, in case their neighbor or somebody new wants to buy it, they don't want to have to pay you commission if they have somebody, right?
Got it.
And then you have an exclusive right of sale. That's one broker, and the listing broker gets paid no matter who sells it. So if you put it up for sale and the neighbor comes over the next day and says, I want to buy the house, you still handle the whole transaction, you get paid.
Gotcha. Is that like so that is a contract?
All 3 of them are contracts.
Okay. And even if they don't use you, are you still entitled to get paid?
Exclusive right. If it sells, you get paid.
Yeah, no matter if you're in a transaction or not.
Well, you have to be. I mean, you're going to do the transaction. You're going to get paid. Like they're not going to go sell it and write the contract. Like if somebody comes to them, you're going to handle it all.
Oh, okay, gotcha.
Yep. And if another agent brings you pay the other agent out of your commission. The way things are set up now, those lawsuits may be changing all that though, right?
Gotcha.
So do you understand the 3 different? Because you need to know these. You'll see questions on this.
Yep, they're a little confusing, but I got it.
Exclusive agency means the seller can sell it on their own and not pay the broker. Exclusive right means the broker gets paid no matter what. And open means it's multiple brokers. Whoever sells it gets paid.
Got it.
Good.
Yep.
Okay, so let's go through these in a little more detail. So the types of listings, you have open listing. One or more brokers are involved. Commission to the broker who sells the property, and that's a unilateral contract. Okay. The broker signing it. It's a unilateral, one person. Exclusive agency listing. It's one broker. Commission goes to the listing broker if not sold directly by the owner. It's a bilateral contract. Now the owner could find somebody and do the whole deal on this. You don't do anything. If they find somebody to buy it, you're not getting paid. You don't do anything. Right?
Got it.
Now, if I ever did something like this, I would say, look, do an open listing agreement or do an exclusive list agency agreement. And I'd offer them, look, if you find the buyer and if you want, I'll do all the paperwork for 1%. You find a buyer and you don't want to handle the paperwork and have a lawyer involved and all that, I'll do everything for you for 1%. Or if I sell it, I'll charge you whatever and a normal deal, right?
Got it.
So I give them that option because they may want you to handle it for 1%, not have any headaches, right?
Yeah, easy.
But the only time I ever offer this is if I'm doing for sale by owners and they're adamant they want to try to sell it. I say, look, I have a contract where you can sell it. If you sell it, you don't pay me. And if I sell it, you pay me. You know, or somebody I bring from my advertising or another agent sells it, you pay me. If you sell it, you don't pay me. Or you can pay me 1% and I'll do all the paperwork for you. I give them that option and I'll write it right in there, right? So that's something that you can offer them if it's a for sale by owner that doesn't want to list, right?
Got it.
And then an exclusive right listing. This is when it's one broker, commission to the listing broker, no matter who procures the property, whoever finds the buyer. And it's a bilateral. They both sign it, right? So bilateral is the exclusive agency, unilateral is open, and bilateral is the exclusive right. Okay, both sign it. Okay.
Okay.
Now let's talk about a net listing. Net listings are illegal in a lot of places. Florida has them legal, but they frown upon them. This is where a commission is paid on a net basis. So an open, an exclusive, or an exclusive right of listing contract can be structured as a net listing. And what that means is the seller agrees to sell a property for a stated acceptable amount, the seller's net, and the broker retains the proceeds in excess of the seller's net. So if a seller says, look, I just want $200,000 for the property, and the agent sells it for $3 million, the agent gets $100,000 and they get $200,000. You can see why it's frowned upon, right? People could be taken advantage of, things like that.
Yeah.
So the formula to calculate this is step 1. You have 100% of the price minus the listing commission percentage. And that's the percentage for seller's net. Step 2 is the total seller's net divided by the percentage for the seller's net. And that gives you the desired sale price. Okay. That's how you calculate what the sale price would be to figure out how to work it out.
Question. But is that not frowned upon as like prohibited? Like we should not do that?
I honestly, in my whole career, I've never done one.
Okay.
I've never done one. I mean, it's not even something I've even approached with anybody.
Gotcha.
I stay away from it. I don't even talk about it,
Got it.
Okay. Now let's look at the multiple listing service. Okay. The MLS is what every agent has to join to become a realtor, right? You could join the local MLS, and then by doing that, you join Florida Realtors and NAR all with the same fee. Okay. A service provided by brokers, not a specific listing type. A clearinghouse for listings with owner's permission in the listing agreement. So they actually give you permission to put it on the MLS. Listings are shared with other brokers. And if the cooperating broker office produces the buyer, the cooperating office receives part of the commission. That's how the MLS system works. Okay, in basic. That's all you need to know for that, for this. Okay. Now, tell you what, let's take a 10-minute break and we'll come back and we'll start buyer brokerage agreements. Okay, let's take a 10-minute. We'll come back at 11:54 and I'll see you in a couple minutes.
Sounds great. Bye.
Okay, so now we're going to go over buyer brokerage agreements. So we went over our contracts in the prior section. We went over all the listing agreements, the types of listing agreements, and now we're going to go over the buyer brokerage agreement. So when you're working with a buyer, okay, an agent has the right to do no agreement and just take a chance, or they can do a buyer brokerage agreement that has the buyer form an agreement to work with them before they spend their time and work. Because if you don't have an agreement, you can work with somebody, they can walk away. There's nothing holding them to you. So if you're going to spend time, money, work, you want to have an agreement with them that you're going to represent them, right? So It's an employment contract with the buyer that includes the following. Okay, the parties and terms of the agreement, who's involved, who's the buyers, who's going to do what brokerage, and the terms that you have, characteristics of property desired, what they're looking for, buyer's obligations, the broker's obligations, a retainer and compensation. You can actually charge a retainer, and it also says what the compensation will be. Okay. And a protection period, how long it's going to last, 3 months, 6 months, early termination and dispute resolution. So if you're going to cancel it or have an issue with it, how it gets treated. And then it's also going to say what authorized broker relationship do you have? Is it single agent, transaction broker, no broker's relationship? Like how are you doing that, right? Okay, so that's how that's going to work. Now you have broker's compensation on this contract. So it's specified in the listing or in the buyer broker's agreement. Okay, so if you find a purchaser, the broker must produce a buyer who is ready, willing, and able to purchase at the terms of the listing contract or at the terms the seller accepts. And you also have to be the effect of a sale. The broker must produce a buyer who is ready, willing, and able to purchase at the terms specified or accepted by the seller and must ensure the transaction closes. That's the responsibility, right? Now, the broker earns the commission and then splits the commission, like the listing broker earns a commission and splits the commission with a cooperating broker if sold by another broker. Now, that's how it is right now. That's the rule. This lawsuit that's going on is trying to change that. And 2 MLSs in the country have already changed that outside of the rule from NAR. So a listing agent does not have to pay the buyer's agent anymore in certain places. This lawsuit that's going on is trying to change that everywhere. They're trying to make it illegal to do that. They're calling it like price fixing and it's unfair trade practice is what they're saying. I mean, the business has been done this way since day one. However, there's this going on right now. So I just want you to be aware of that. But as of now, this is how it works. The employing broker, which would be the listing broker, splits the commission with the associate involved in the transaction. The cooperating broker splits the commission with the sales associate involved in the transaction. And the sales associate receives compensation from the employing broker. So what this is saying is, if the commission is $15,000 and it's split 50-50 between the 2 brokerages, the listing brokerage gets $7,500. The selling brokerage, who the agent for the buyer is, the selling brokerage, gets $7,500. That goes to the brokerage. And the brokerage applies the split commission they have with the agent, and then they pay the agent their commission from their broker. Does that make sense?
It makes sense, yeah.
Okay, just want to make sure. It's a little confusing how it's worded, but that's how it breaks down.
It's very confusing. I appreciate you letting me know.
So, so the commission goes to the selling broker, the listing broker. They're the ones that have the agreement. So the commission goes to them, and then it's all paid at closing, but that's how it works on paper. Okay.
Okay.
So the broker earns the commission and then splits the commission with the cooperating broker if sold by another broker. Okay. I'm reading what I just did. So you got that. Okay. Now the commission checks. Closing agent can legally prepare a check payable to the associate for the associate's share of the commission. The broker must give the closing agent written authorization and instructions regarding the amount of the commission the sales associate is to be paid. You cannot give blanket authorization. So an agent could be paid by the closing department if the broker allows for it. Commission checks continued. So it goes in a little more details. To be paid, the broker must hold a current active license at the time the listing or buyer agreement is entered into and real estate services are conducted. You got to be employed through a listing or buyer broker agreement. And you have to be the procuring cause. A procuring cause is the chain of events that resulted in the sale. As a buyer broker, you had to be the one that showed the property, took them to the property. You're the procuring cause. You brought them there. That's what needs to be done to be able to get paid. Okay. So that talks about buyer broker agreements. Do you have any questions on that?
I think I did on 2 slides ago. I think on the 28th, perhaps.
Mhm.
Yeah, that part. The closing agent and all that stuff. Like, who's the closing agent?
The closing agent would be the title company. That's the person who just sent me the documents I showed you.
Okay.
That's the title company. Here's all the numbers. They're the person who issues the checks. They wire the money.
Okay.
Okay. So at closing, they could get the check directly to the agent, or they'll get the check to or the money to the broker. Then the broker pays the agent. However, the brokerage is set up.
Okay. Okay.
Okay.
So either way, like the money's gonna get to the listing sales associate either way, but it can either go to the broker who's then gonna send it to them, or directly to the sales agent from the closing agent, which is the title company, with the
If the
instructions
broker allows for it.
yeah, the instructions that were given by the broker.
Right.
Okay.
So for example, as a brokerage, I had them send me the money, then I pay the agents
Gotcha.
for track of it. And then the other thing is when a file is closed, there's things that the agent has to do before it's closed for me because I have to have records. So if
Got
the
it.
agent is missing a paper or two papers, they're not going to get their commission until it's full.
Makes
So it's
sense.
done. So I'm not going to get paid at closing. Once I see the file and I get all the documents from closing and I see all the files are in there, and if they're missing something, they have to give me that before I pay them. Because try paying somebody and trying to get a piece of paper after you pay them.
Oh, yeah.
You
That's a
know?
hard one.
Right. So you make your file complete and here's your check. Right.
Got it.
That's part of my policies in the manuals.
Gotcha. Yeah, in my job, we have that too. We call that perfect packet.
Yeah, exactly. Because we need to keep that for 5 years.
There we
If
go.
something comes up, I got to have all the documents, right? So now let's talk about a little bit more. Okay, we did this. We did the commission checks. Now we talked about listing agreements, buyer broker agreements. Now we're going to talk about option contracts. Okay. Remember, an option contract is unilateral, right? The seller is committing, the buyer has the option. It's an agreement to keep open for a specific period of time an offer to sell or lease real property. The property owner is the optionor. It grants the buyer, who's called the optionee, the exclusive right to buy the property for a specific price and terms within a certain period of time. It's a unilateral contract. The optionor, the seller, is bound to perform under the terms of the option. The optionee, who's a buyer, is under no obligation to buy the property. So the seller's locking themselves up. They can't sell to nobody else. They can't do anything. Okay.
I'm not full on that one.
I'll explain. Yeah. So this is like if you lease a property, you do a lease option. You lease it for a year, and in that year you can buy it for like they'll give you an option to buy it.
Oh, like rent to own is what they
Rent to
call
own. Yep. Exactly.
it. Okay.
Yep. So consider it. There got to be a consideration for right to purchase under terms of the option. The terms and the provisions required of a valid contract all have to be there. The options assignable unless prohibited in terms of the agreement. So the buyer can say, I'm not going to buy it, but I'm going to sell it to this guy over here and make a little bit of money on it. Like I'll sell it to you for $100,000 in the next 12 months. Market goes up. It's worth 150. I can take that and sell it to somebody else for 150 and make the 50 grand.
Got it.
Now, the seller can put in there that that's not allowed. If that's not allowed, you can't do that. Right. Okay. Consideration. You have to put money down. So you have to put a significant consideration. So if you're doing this, you got to put 10, 20 grand down and it sits in escrow. It's your money. If you say, oh, I'm not going to buy it, you get your money back. But it just got to sit in escrow all that time.
Got it.
Okay. And the licensee requirements is a substantial valuable consideration. You got to put a decent amount of money down to make it a valid contract. Okay. So now we talked about options. Let's talk about sale and purchase contracts in a little more detail. Okay. What you need to remember for this is in a sales and purchase contract, there's two parties, the seller and the buyer. The vendor is the seller, the vendee is the buyer. It's a bilateral contract. The buyer and the seller both have to sign it. And it has to be in writing and signed according to the statute of frauds. Okay, that's what you need to remember about a sales purchase contract.
Question for you. Because I've noticed that there's a lot of vendor, vendee, trainor, trainee. There's so many of them. But I just want to kind of make sure that I remember correctly. You said that every time there's an OR at the end of the word, that means that is the person selling the property.
The vendor is the seller and the vendee is offering.
Okay.
Yep. There's some exceptions to that, but when you think about it, the vendor is the seller, the vendee is offering on it. They're trying to buy it on a sales contract.
Okay.
Okay. Now, information that's on the sales contract, the names of the seller and the buyer, vendor, vendee, legal description of the property, the consideration, how much they're putting down, the down payment or the deposit. Sorry, the deposit, not the down payment, the deposit. The purchase price. If it's financing or cash, the type of deed the seller will deliver. Remember, if there's no deed mentioned, what is it? What's the default?
If there is no deed mentioned, then it's gonna be don't tell me, please. Fee simple.
Well, no, fee simple. Fee simple is the fee simple is the is a type of title they're taking. That's the ownership rights.
Oh, okay.
Remember, it was a type of deed, something deed, a something deed. Remember, you had quit claim deed, you had all those. Remember those?
Wasn't it general
warranty deed.
General warranty deed, yeah. That's the
General
one that
warranty
gets the most.
Got it.
Yeah,
Yep.
most protection.
Like if you've seen that in a multiple choice question, you would get that.
Oh yeah, definitely.
Because right? Yeah, just to memorize it's a little hard.
Yeah,
but if you've seen that, a general warranty deed is the
Yeah.
Okay. Title evidence to be provided, the chain of title and opinion. Expense and prorations to be paid. Like if there's a renter and there's rent to collect and you got to get the all situated, who gets what at closing. Prorations are taxes and insurance, and you got to make sure all that's figured out. Personal property, if it's included, the washer and dryer is included, the washer and dryer is not included, right?
Got it.
Date, time, and place of closing, and when possession of the property will occur. At funding, sometimes people move into the house before closing, after closing, right? That all has to be in there.
Got it. Question. Can the consideration be referred to as earnest money?
Correct.
Okay, thank you.
That's the deposit. The earnest money is consideration.
Okay, thank you so much.
Correct. Now you have the spouse's signature. If a property is owned by a married couple, which is tenancy by the entireties, or if the property is in a homestead and the ownership is only in one spouse's name. Remember, in severalty is one name?
Yeah.
Then both spouses must sign the contract and the listing agreement and the closing documents, right? And the deed, right?
Okay, got it.
Okay. Now, power to bind the seller or the buyer. The broker does not have the authority to sign a contract for the buyer or the seller or to bind the buyer or the seller to a contract unless power to do so is granted. That's called a power of attorney.
Sorry, what does it mean by bind?
Bind them. You cannot sign them. You cannot bind them. You can't sign for them.
Oh, okay.
They have to sign it. They have to commit to it. Okay. Binding, that means you could sign. Now, when you have a power of attorney, the seller can give you the power of attorney to sign for them for closing. Right? You can't sign the listing agreement. You can't sign the contract. Nobody can do that but the buyer and the seller. But to do the documents, say they're out of town, say they're not there, say they want you to sign for them at the closing, they can give you a power of attorney. And that's a written legal document designated another person as attorney in fact for that transaction. Okay, so that's a power of attorney. Then there's a special power of attorney that limits to one specific act. So they'll give you that. They'll say you can sign for me for this closing for this property. That's it.
Got
Okay.
it. Question. So if you do have the power of attorney, then you are able to sign all documents for the buyer or
No.
seller.
Well, the closing documents. You cannot sign the initiation documents. You cannot sign the listing agreement. You cannot sign a contract, a sales contract.
So how did that work with you? You mentioned that you had
Yep.
originally
My
a
friend was in
sale.
Afghanistan. The listing agreement, I sent him digitally. He signed it online.
Oh, okay, gotcha.
The sales agreement, he signed digitally online. I could not sign that for him, even if I had a power of attorney. That's not allowed. That's Florida
Okay.
law. That's statute.
Um, Now, did he sign all the documents online, or are there any
He signed
documents?
all the documents for listing and all the documents for selling. When I listed his house, then we got the offer. He signed the offer. He signed the contract. He signed everything.
Then
And
then
then
why then why do you need the power of attorney then if it could
because
just go?
for a deed and for closing documents, you need wet signatures. You can't use digital.
Oh, deed and what else?
And it depends on the lender, it depends on the documents. Some will use digital, but the deed for sure, 100% has to be physically signed. You can't do
Okay.
digital.
Okay. So deed and what else? I'm sorry.
What's that?
Deed and what else?
Deed and whatever documents the lender decides. The
Okay.
deed 100%. Other documents, it just depends on the situation.
Got it.
Make sense?
Makes sense.
All right. Good. Now let's talk about material defects. Okay, remember material defects is a problem with the property, right?
Yeah.
So seller of residential property must disclose material defects. There was a court case in the Florida Supreme Court, Johnson versus Davis. Okay. And in this case, you have to tell people if you had a leak in the house and it's fixed and it happened, you have to tell them that. If the seller doesn't tell the agent that and the seller doesn't tell the buyer that, it could be an issue. They can sue them. So one of the things I do whenever I list a property, there's a form called a seller disclosure. And it's a 4 or 5 page document and it goes to all these questions. And they put yes, no, or I don't know. I make every listing sign that. Now it's not required in Florida to do that. But what it does is if a seller isn't disclosing something to me, they're going to put it on there and they're going to lie about it, right? Or if they are disclosing something, they're going to tell me there. And then I have to tell the buyers that.
Got it.
So what I do is that paper, if they're going to lie, because if they lie to you and they say there was no roof leak and there was a roof leak, and 4 years from now they find out and they sue them and they tell, well, I told my agent there was a roof leak. Well, no, you didn't. It's my word against theirs, right?
Yeah. We have
So when
documented
I have it on paper saying there was no roof leak, and they say 4 years from now, well, I told them, I pull the paper out and say, no, you didn't.
Got it.
Right? So I do that on every listing. If somebody does not want to sign that, or somebody does not want to be honest on that, I don't take the listing because I don't have time for it. I'm not going to lie for people, do things, right? If for any reason somebody doesn't want to do that is because there's something wrong.
Yeah.
Right? So that's something that's very important to do. And you can't help them fill that out. On the form, it says they must fill that out. Like it's part of the digital. They go in, they click every button, boom, 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 as they're going through. You know?
Got it.
Okay. Okay. So there is a as is provision. It does not circumvent duty to disclose. There's a contract. It's called the as is contract. They're buying the house as is. They're still going to have an inspection. If they want to have repairs done, they can still negotiate that. But it's buying the house as is. The seller's not required to repair anything. They can come in, do an inspection, say, I want a roof for $10,000. The seller can say, no, buy it the way it is or don't buy it. The seller doesn't have to say, okay, I'll fix the roof. That's what as is means. It doesn't mean you're buying it as is if there was a leak and I'm not telling you, right?
Gotcha. And
That's what that means.
can it be as is and also have a general warranty title or
Sure.
no?
Yeah, absolutely. That's nothing to do with it. Yeah, absolutely.
Okay, okay. Because the title itself, well, the as is more referring to the condition of the property physically, and then
Correct.
the warranty title is more referring to like, oh, this doesn't have any lanes that
That's
any
what
means.
the warranty, the deed, the warranty deed gives you the rights to the property to do what you want with it.
Okay.
Remember, general warranty gives you the most rights. Special warranty gives you from certain to certain, right? You know what I mean? Like there's different rights. It's the bundle of rights, remember?
Yeah. Yeah.
And the fee simple. Remember all that?
If it's simple title, yeah.
Okay. This is more about the condition of the house and disclosing. So you as an agent, if they tell you there was a roof leak, if you found out there was a roof leak, you must disclose that even if they didn't tell you. If they tell you we had a roof leak, but I don't want to tell nobody, you got to tell them, I got to disclose that. You can't tell me that and I can't hide that.
Oh yeah.
Right. So information that is not a material fact. This has been decided by, law. Okay. Material defects concern the property and not the occupants. Okay. So it's about the property, not who lives in it. So fair housing law and Florida statute state that the occupant's information is not a material fact to be disclosed. So if somebody had HIV or AIDS in the house, lived, died, you don't have to disclose that. Okay. If the home was a place of a homicide, suicide, death, that's not a material fact. You don't have to disclose that.
Got it.
Okay. It's about the house, not the physical house, not the people or any things like that happened in it. Okay.
Gotcha.
Radon gas disclosure. Okay, a required radon gas disclosure statement on sale and lease contracts. The information regarding radon gas, and it does not require testing for sale or lease. Radon gas is a gas that comes from limestone in the ground. Florida, there's not a lot of radon gas. There's not a lot of limestone in the ground here. Tennessee, I had to deal with this. They have remediation. There's things they do. They drill down in the ground. They put fans in. They take the out through pipes to remediate. Radon is a cancer-causing agent. It comes from the earth. There's nothing you can do. It comes from the mountains. Everywhere has it. There's nothing you can do about it. Okay. Lead-based paint disclosure. Now, in this case, anytime you're showing property that was built before 1978 or before, you have to give a pamphlet to the buyer. By law, you have to give that to them. And it explains what lead paint is, the effects of it. It applies to all homes built prior to 1978. And there's a disclosure either as a separate document or the disclosure may be incorporated into the sales contract or lease agreement. It's a disclosure that goes in there if it's an older property. And you have to say if there's any lead paint or if you know of anything, the buyers and sellers initial. I actually got to sign it as the broker. Both brokers sign it. That's called a lead paint disclosure. Okay. Now it's homes built prior to 78. The seller or landlords must disclose presence of any known lead paint. The buyers or renters must be given an EPA booklet. That's the pamphlet I'm talking about. Sellers must allow the buyers to conduct an inspection within 10 days. The inspection is not required and the seller is not required to pay for it. If the seller or landlord does not comply, a buyer or tenant who is harmed by the presence of lead paint may sue the seller or landlord. And there's contractor requirements. You have to have certain requirements to remove it. The way you remediate lead paint is by painting over it. So as long as a house was remodeled or repainted after 1978, there shouldn't be any lead paint. Now, if the paint chips and it comes off, now there could be lead paint, right? So that's what you got there. Now, you also have something called an energy efficiency disclosure. Now, just we just needed this. The deal that's closing tomorrow, the builder never sent this documentation to the lender. So we had to, like 2 weeks ago, to be asking for it. They just sent it to them. So now everything's good. They needed this before they can clear it to close. So the Florida Building Efficient, there is a Florida Building Energy Efficient Rating Act. Buyers at the time or prior to signing the sales contract receive an information brochure stating the purchaser may get an energy efficiency rating. They never gave that to us. It created a uniform statewide energy efficient rating system of new and existing buildings. The rating systems apply to public, commercial, and residential structures. Okay, so this is just something that could be provided to you if the building fits in these guidelines. Okay.
Got it.
Homeowners Association disclosure. This is what we talked about. Remember, if it's a resale homeowner or co-op, they have 3 days to review. Remember, 3 days or 15 days if it's the builder.
Yes.
This is the disclosure they get when you're selling a condo, or I'm sorry, when you're selling a homeowners association property, scratch condo. The homeowners disclosure, it's like a condo disclosure, same kind of thing. But when you're in a development and there's an HOA, you must give them the homeowners association disclosure. Says the same information about it, how much a month, who you pay, who the contact is. It says the property is subject to mandatory homeowners association. It provides the buyer with the disclosure regarding the association fees, restrictive covenants, and assessments. There's a 3-day right of rescission if not received before signing the sale contract. Okay, it cannot be waived. Now, if they don't get it, let's say they never get it and they close the deal. Once the deal closes, they're out of luck. It dies. You cannot request it after closing. So you have all the way up until closing. So you can do a contract. When you do a contract, you give them this at the same time. When it's executed, you give them this right away because you have that 3-day period. If you don't give them this and they ask you 2 days before closing for it and they don't like something, they can get their money back and cancel and walk away. You want that 3-day period to go with the inspection period, right? So now if they close the deal and 3 days later they find out they can't have a dog there, it's too late. That's their problem, right? Because it ends at closing. There's no after closing repercussions on this.
But they most have received it for that to be the case.
Most agents will give it to you, and you want to get it too because you want to make sure the deal's solid and everything's right. You don't want to have any problems, right?
Yeah.
Okay, good. Good. It's good for that. Okay. Okay, property tax disclosure. Okay, disclosure summary concerning ad valorem taxes before or at the time of execution of a contract for sale. You must disclose all the taxes must be there. Buyers should not rely on the amount of the seller's property taxes as an indication of the taxes purchasers will be required to pay in the year following purchase of the property. You can't look at the taxes that they're paying now. It's based off what you're buying the property for and what your homestead exemptions are if you have a homestead. So you can't say, oh, they're paying $8,000 a year in taxes, I'm going to pay $8,000. No, it goes on. That it's a separate thing. It's just because they're paying that don't mean the buyer's paying that. Okay, you have to do a whole new calculation for them for what their taxes will be. Does that make sense?
It does. Will I learn how to make the calculations?
Yeah, oh, absolutely. You're gonna be tested on them. Yep.
Okay.
Yep. We're gonna get into that. You got to figure we're 11 sessions in. We got 19. We got 8 more sessions.
Okay.
Just of this stuff, and then we got the review, we got the cram, and we got the practice exam too. Before you take your exam for us and then the state.
Amen.
Okay. Building code violation disclosure. A seller must disclose the existence and nature of any violations. Copy of the pleadings notice from the city or county. If the buyer will be responsible for compliance with code. The seller must forward the name and address of new owner to the code enforcement agency within 5 days. So if there's any compliance issues and they're buying the house, they must tell the new owner that they're responsible for any issues, and they have to give the information to the zoning people within 5 days of selling the property. Okay, that's if there's any outstanding violations, things like that. Okay.
What kind of violations would those include?
Zoning, it could be it could be if a fence is up and it don't belong there. It could be the house can be tenants can be in there and it might need work, and they can make a complaint and they can put a zoning violation against you for something, electric problem, plumbing problem, things like that.
What about a pool that does not?
Yeah, if you put a pool in, it's not zoned. You got to, yeah, you have to take it out. Yep.
Got it.
Anything that is a violation, it can be anything. Yep.
All right.
If you parked a car with labels on it and they gave you a fine and you weren't supposed to have a car with labels on it, that's something like this. Anything.
So does that mean that the person, the previous owner or the seller,
Yep.
had to pay because they got fined for whatever violation
Right.
it was?
Right.
Has they paid at this point, or have they not?
This is what it is. They have to pay it at closing, or the new buyer is responsible.
Okay, gotcha.
So that's why they'll usually make them pay that at closing, or they got to tell the buyer and then they take it off the price or something. Like they got to negotiate it.
Gotcha. Does that also include like let's say they own like property taxes, or they have like
Yeah.
any
Yeah, absolutely. Well, no, property taxes as well, but that's not this. This is just
Okay.
about building code violations.
Oh, just build. I'm building
If
code.
you owe back property taxes, you must pay them at closing. The seller comes out of their profit.
Gotcha.
Yep. That has to, because they have to be paid before it can transfer, because that's a lien. That's a lien on the title. Like that's a lien. So that has to be paid, just like a mortgage would have to be paid before it can transfer.
Got it.
Yep. Okay. I had a client that had a 4-unit build or 3-unit building, and he had $50,000 in fines. He didn't know about them. Something weird went on, and he had $50,000 in fines. We found out about it. I had to tell the buyer, went to the city, filed everything. I ended up getting it reduced to $5,000 from him.
Nice.
So he only had to pay $5,000. But it was a nightmare. It was a night. I almost lost the deal.
Sounds like a nightmare.
But you know how to do things. You get things done. Most people, wouldn't do that. I know how to get things done. We kept the deal together and it was done. Saved the guy $45,000. So that's an example of that. He had back taxes too. Back tax had to be paid. Yeah, it was a mess. It was a tough deal. Now you also have community development districts. They're called CDDs. We have them here. So these are independent special districts. Okay, like for example, it services the long-term needs of the community. It constructs, operates, and maintains infrastructure services. The developer finances the construction of infrastructure by using bonds. The homeowners repay the bonds through tax assessments. And there's written disclosure in initial contracts for sale. So for example, the house we're selling in the Villages has a CDD. There was a bond. Once it's paid off, it goes away. It's like $180 a year or something. Or it's like $300 a year, but there's $7,000 left on it. So that has to be disclosed in the contract. So the new buyer will take that over and pay that off. And then once it's paid off, it goes away. That makes sense? So the builder would do this this is when they're not dedicating the streets. This is when they're not doing that. So to maintain the streets, to build the streets, to do all that, they get a CDD. And then they divide it up among all the homes. And then all the homes pay that in addition to an HOA fee or whatever for the amount of time to pay it off. Then once it's paid off, it goes away.
Oh, because he does get paid off. It's not like a
right. Yeah, because the homeowners are paying it, not the developer. The homeowners are paying it because it's their usage.
Okay, gotcha.
Okay, and you always got to look and see if a development has these. When you're listing a property, you have to find out there's a CDD.
Got it.
Okay. Now let's talk about misrepresentation and fraud. Okay, misrepresentation is a misstatement, an omission, or concealment of a factual matter. Okay, that's a violation. That's a law broken. Misrepresentation. That's when when you hide something, or you don't, or you know something and you say something different. Okay, then you have fraud. Fraud has 4 elements of cause of action. Okay, it has to have these 4 elements to be fraud. The licensee must make a misstatement. The licensee knew that the statement was not accurate. The party relied on the misstatement, and then the party was damaged as a result. So some agent says something, they're not sure if it's true, or they don't know if it's true, but they say it. Okay, like, you want to buy this house? Great. I want to put Airbnb units here. Can I put Airbnb here? Yeah, you can put Airbnb here. But let's say you can't put Airbnb there. The person buys it, and then they find out they can't put Airbnb there. They're damaged by that, right?
Yeah.
There you go. Example.
That's a good example.
So if you don't know something, you say, I don't know, let me find out.
Yeah.
Right? You don't say, I think so, or, let me find out. Or you don't say yes if it's not. Let me find out. Right?
Got it.
Okay. And this is the end of section 11